Welcome to Crime in Court. My name is Heather, and this is another stream about the Delphi case. We've been trying to stay up to date in all the different court filings that have been going on in the Delphi case, and reading the motions and reading through the transcripts and things like that. So we're trying to really understand what's going on in the Delphi case and what's happening in Indiana versus Richard Allen. And this is, of course, for the justice of Abby and Libby. So we are going to, in this episode, talk a little bit about the latest filing. I'm showing you the thumbnail because I was going to show you the title of this episode is Allen's Defense to Call Judge Gull as a Witness. So we're going to take a look at this latest court filing from Richard Allen and his defense team, and see what they have to say. So they recently filed their second motion to disqualify or dismiss, or not dismiss, but to disqualify Judge Gull. Judge Gull. They've asked her to recuse herself. She's refused. They've asked her again. She's refused again. In this latest order, she came back with all the reasons and whatnots, and we read through it. And because before in the past, she would just say everything was just denied without hearing. But in this past filing, she had to give some kind of, well, they asked her to give some kind of legal basis and facts. What facts are you using to find whatever legal basis you're looking at? So they got a little bit more from her this last time, excuse me. Um, it was more than just a denied without hearing. So that was good. They got some information. They got we read through the whole order with the denial and everything. So now we're going to read what the accused has to say in response to that order of judgment and notice of conflict. So comes now the accused, Richard Allen, by and through counsel, and files his response to this court's May 31st, 2024 order or judgment of the court and notice of conflict. In support of said motion, Mr. Allen states the following. Number one, on May 31st, 2024, this court issued its order or judgment of the court concerning the defense's request to have Judge Gull disqualified. Number two, contained in said order were several errors. The defense is filing this motion to preserve those errors for future courts if needed, and to notify the court that due to new information new information learned in her order, a conflict has been revealed which has caused Judge Gull to become a witness. Uh-oh, Judge Gull, you really stepped in it this time. So let's find out why. All right, so number three, the defense files this response and notice for purposes of maintaining a record and does not wish for this pleading to delay future hearings from taking place, particularly hearings related to the defense's request to transfer Richard Allen out of the Department of Corrections, which is the most urgent of the pending matters that need litigated. They want him moved out of the Department of Corrections back to a county jail where he can be held temporarily until trial, which is what most defendants, that's what most defendants receive, that treatment. They're usually kept in a county jail, and if and when they are found guilty, then they move them to the prison. But this is not the case for Richard Allen. He is being held with all of the people who have been convicted of crimes, but he's not even allowed to see people because they've been keeping him in isolation and just doing a lot of possibly irreparable harm to him mentally, emotionally, maybe even physically. So, there's that. Number three, Did I get there already? The defense files this response and notice for purposes of maintaining a record. Okay, yeah. Sorry. Which is the most urgent. The most urgent. They want him moved out of the county jail. Right. Okay. I have to remind myself. It's like my own brain has to remember the things that I already just said. All right. So also, the defense's response is intended to provide correct information to Judge Gull as she continues to self-evaluate her obligation to recuse herself from the case should she believe that bias or the appearance of bias exists. And footnote 1 says a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. And that is Abney versus State. Up next, Judge Gull failed to inform the defense that Carroll County Sheriff's Office fabricated facts in a report filed in her court. So, just to kind of give you a little brief synopsis here, there was a hearing on June 14th, 2023, and they were supposed to have this fellow inmate, Robert Baston, Richard Allen's team was supposed to have Robert Baston come and testify on Richard Allen's behalf because Robert Baston was claiming that he had seen the guards mistreating Allen and um, some bad situations going on there. Um, so he was supposed to testify, but he never showed because, well, he was afraid to come. I believe he was being threatened. And also, Sheriff Tobe Lesenby did not um, force him to come. And in his report, apparently, he noted that it was Judge Gull who said Robert Baston didn't have to go, even though he had a subpoena. Okay, so that means even Judge Gull couldn't well, she could say whatever, but they had a subpoena, and the only person that can say a subpoena is invalid would be another judge, I guess, is what I was trying to say. So Robert Baston doesn't show. Tobe Lesenby, the sheriff, says, well, Judge Gull said he doesn't have to come. And then in this most recent order, the judgment order or judgment, but from Judge Gull, came out that she was stating that it had nothing to do with her. And it was all whatever, Tobe Lesenby and their decision, and Baston didn't want to come and blah, blah, blah. So she claims no accountability for it, but by doing so, she made herself a witness. So we have brought Judge Gull in as a witness now to this case. So, number 4, in his motion to disqualify, Mr. Allen noted that according to a June 14th, 2023 report filed by the Carroll County Sheriff's Office, hereinafter CCSO, Judge Gull advised the CCSO that it could ignore a valid defense subpoena for Westville Correctional Facility inmate Robert Baston and refused to transport him to the June 15th, 2023 hearing on Mr. Allen's emergency motion to modify safekeeping order. So this was to get him out of the Department of Corrections yet again. Like this has been going on for a year now. Or well over a year that they've been trying to get him into county jail rather than the state's Department of Corrections, where even Judge Gull apparently has no control over. Uh-oh, my bread's gonna bake or it's done. I don't know, it's beeping. It's probably, I don't smell bread, so it's beeping at me for reasons I'm not sure. You guys probably heard that. All right. All right, so inmate Baston didn't come. They're saying he refused to come, or he refused to transport him. Hold on, let me back that up. So Judge Gull advised Tobe Lesenby, the sheriff, that they could ignore a valid defense subpoena for Westville Correctional Facility inmate Robert Baston and refuse to transport him to the hearing back in June of 2023 on Mr. Allen's emergency motion. The defense further alleged in its motion to disqualify that because of Judge Gull's actions, the defense was without a key witness for that hearing. Number 5. It was anticipated that at that June 15th, 2023 hearing, Mr. Baston would testify to the harsh, abusive, and unconstitutional treatment of Richard Allen at Westville Correctional Facility. 6. The failure of the CCSO to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, thereby subverting justice for him. Number 7. However, in her May 31st, 2024 order, Judge Gull claims that she never advised the CCSO to ignore the subpoena and leave Baston behind. 8. Judge Gull's claim contradicts the CCSO's report that the court received on June 20th, 2023. Number 9. The June 14th, 2023 report, which was ordered by the court, stated the following. On June 14th, 2023, I, Special Deputy Wysocki Bryan, while on duty, was conducting transport from Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to Baston Robert, and there's his inmate number, segregation unit to conduct the pickup. After waiting, a corrections officer approached and told me Baston is refusing to come out of his cell and told the corrections officers, "Fuck you, you can't make me go." The corrections officer told me they will do a cell extraction to get him to my transport vehicle. I told the corrections officers to stand by and let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gallipo, or Gallipo, sounds good. I don't know. I called Carroll County Jail Commander Lori Sostarczyk, who I explained the situation to. She then made a phone call to Chief Deputy Tobe Lesenby, who contacted Judge Francis Gull's office to inform them of the situation. Judge Gull's office advised to leave Baston there if he did not want to attend the court hearing that is scheduled for 6/15/23. So Judge Gull said, just leave him there if he doesn't want to come. Who cares about subpoenas? Subpoena shmeena. Just let him stay there. I then spoke with Warden Gallipo and asked if he could provide me with a letter stating that Baston refused to come out of his cell, that he did not want to go. Warden Gallipo agreed he would. He later advised he would bring me the letter on 6/15/23 to Carroll County Courthouse so I could attach it to his report. Nothing further at this time. Number 10. The report was approved by Tobe Lesenby, who is a key witness in this case. 11. Juxtaposed to the CCSO report in Judge Gull's May 31st, 2024 order, in which she stated the decision by the deputy to leave without the witness was his and was not directed by the court. Meaning her. She didn't do it. But that is not what we're getting from the report. So somebody's lying. Number 12. The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. So the most recent filing prior to this. 13. Judge Gull has possessed this report since June 20th, 2023. So she should have known that that's what that said. 14. Upon receiving this report nearly a year ago, Judge Gull never notified Mr. Allen's attorneys of the misrepresentation contained in the report as it related to her purported involvement in the failure to transport Mr. Baston to the hearing. Number 15. At the very moment of learning that CCSO filed a report with fabricated facts concerning Judge Gull, she should have immediately alerted Mr. Allen's attorneys of the misrepresentation contained in the report. 16. Further, upon Judge Gull learning of the misrepresentation contained in the report, which undermined the evidence Mr. Allen was able to present, Judge Gull never reset the hearing so Mr. Allen could present the very evidence Judge Gull said was lacking when she denied Mr. Allen's emergency motion to vacate safekeeping order. Can't have it both ways, Judge. Number 17. Additionally, as this court is aware, Mr. Allen has filed 4 Franks motions indicating that law enforcement has acted intentionally or in bad faith. 18. Also, as this court is aware, Mr. Allen has filed 2 separate motions to dismiss based upon law enforcement's destruction of evidence. One of those motions was heard on March 18th, 2024, with the court denying said motion on April 2nd. 19. To prevail on a motion to dismiss as it relates to the destruction of potentially useful evidence, the motion to dismiss requires the defense to prove that law enforcement acted in bad faith. That's Pimentel versus State. 20. At the March 18th, 2024 hearing, defense counsel was attempting to provide evidence to the court that law enforcement has acted in bad faith over the course of this case. At that time, the court was aware that law enforcement had fabricated facts contained in the June 14th, 2023 report, thereby acting in bad faith. Yet, this court never alerted the defense, and therefore, law enforcement's bad faith was not made part of the record. So, somebody's bad faith, whether it's Judge Gull's or law enforcement, it needs to be on the record and accounted for. 21. Even if this court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the fact is that the defense was not able to include that information on the record for the Court of Appeals should it be necessary. So you screwed with our record, lady. Number 22, additionally, had Judge Gull alerted Mr. Allen's attorneys of Carroll County Sheriff's fabricated statement in that report, the defense could have used that fabricated statement when pursuing their Franks motions and motions to dismiss in order to provide additional evidence of intentionality and bad faith on the part of CCSO. So, Judge Gull, either you're lying or Tobe Leathenby was lying and you knew it and they were acting in bad faith, and that's just another item to add to the list of all the bad faith items that we already have. And so, Judge Gull, this is more proof that they are acting in bad faith if they lied on a report about you. You should be mad about that, Judge Gull. But no. 23. Furthermore, by failing to provide this information to Mr. Allen's attorneys, Judge Gull prevented the defense from investigating this fabricated story, including through depositions. So they could have investigated it further had they known. 24. Judge Gull should have alerted Mr. Allen's attorneys of CCSO's fabricated facts written in their police report well before the March 18, 2024 motion to dismiss, and her failure to do so provides a rational inference of bias. Yeah, it does. Judge Gull is now a witness in this matter as to Tobe Leathenby's credibility. 25. Given that Judge Gull is the only individual who knows that she did not direct the CCSO office to ignore the subpoena and leave Mr. Baston at Westville, despite the contrary assertions in the CCSO's report, she has become a witness to Tobe Leathenby's truthfulness and to the fact that the information contained in the CCSO's report is false. So, her versus him. Who do we believe? We need to see them both testify to it. Number 26, the credibility of a witness is always an issue for the jury. Stanley versus State. Number 27, if Judge Gull's story is correct, then she had a ringside seat to the intentional behavior of the CCSO and or the bad faith of the CCSO in that it, one, intentionally ignored a valid defense subpoena for a defense witness, and then two, fabricated a story in a police report claiming that the sitting judge on the case authorized the CCSO to ignore the valid defense subpoena. In this scenario, Judge Gull is a witness. Dun dun dun. You did it to yourself, Judge Gull. Oh, it's beautiful, isn't it? I like it. 28. At future hearings and at trial, the defense should have the ability to cross examine Tobe Lesenby on these contradictory stories with questions similar to the following. Attorney: Mr. Lesenby, the defense attempted to bring a witness named Robert Baston to testify at a hearing concerning his observation of guards abusing Richard Allen in a variety of ways at Westville, but your office ignored a valid subpoena to bring that witness to a hearing. Isn't that right? Or you did not want the judge to hear the testimony of that witness because it would support the defense's contention that Richard Allen was being abused and should be moved to the Cass County Jail closer to both his family and attorneys and away from the abuse. Also, you wanted Richard Allen to remain at the Westville prison so that he would continue to be housed far away from his attorneys and family while emotionally vulnerable to the abuse he was suffering at Westville. Or worse yet, you then lied in a report claiming that Judge Gull advised you that it was okay to leave Baston behind. You lied about that in your report. Or Judge Gull never told you that it was okay to ignore a valid defense subpoena, did she? So they're playing devil's advocate like, okay, Judge Gull, we believe you that you didn't tell him to ignore a subpoena. So these are the questions we would be asking him because we needed to get to the bottom of that. And you should be outraged, Judge, because he lied about you. Last question here. I am handing you Exhibit 85, which is the June 14th, 2023 report from CCSA. I think they mean CCSO, in which you claim that Gull gave the directive allowing you to ignore the subpoena, etc., etc. You can go on and on with different questions you could ask Lesenby as to why his statements of what happened with Baston may differ from what Gull is saying happened. So 29, because the defense is claiming that law enforcement has acted in bad faith and bad faith is an important component in its motions to dismiss as well as the four Franks notices, it must be able to call Judge Gull to the stand to testify concerning the false statements contained in the CCSO's June 14th, 2023 report. Judge Gull's testimony is especially vital concerning the defense motions to modify the safekeeping order, as well as their Frank's motions and motions to dismiss. 30. Calling Judge Gull to the stand to testify as to the fabricated facts contained in this report is especially important when the very witness who is the subject of the report would have testified about Richard Allen's treatment at Westville, which directly led to the deterioration of his mental health and false statements concerning his involvement in this crime. Number 31, the defense plans on issuing subpoenas and calling Judge Gull to the stand at future hearings and at trial to testify that she never directed CCSO to ignore a valid subpoena and also never advised CCSO to leave Robert Baston behind if he did not want to attend the June 15th hearing. So they plan on issuing subpoenas and calling Judge Gull to the stand to testify about this. They are not mincing words. We will call you, Judge. Judge Gull should recuse herself from this matter as she is now a witness from the proceedings. Yeah, she should have recused herself a long time ago, but she didn't, and that's why we're here now. Judge Gull's failure to admonish the CCO may cause law enforcement to believe that they can create fabricated stories in this case with no consequences. Number 33, despite having the CCO report since June 20th, 2023, to this day, Judge Gull has failed to admonish the CCSO for filing a report that contains such a flagrant falsehood about her and which is arguably an attempt to cover up their illegal actions in ignoring a valid defense subpoena. Number 34, Judge Gull's failure to address that fabrication in any fashion whatsoever provides a basis for state's witnesses to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence. This provides a rational inference of bias. Hold on one second. Sorry about that. All right, back to it. So Judge Gull continues to errantly. Yeah, I did read 34. Okay, so Judge Gull, sorry. Judge Gull continues to errantly accuse the defense of improperly filing ex parte documents. Ex parte means one sided, so it means only the judge and that whoever's filing it can see it. It's not meant for the other side. So in its May 31st, 2024 order, this court continued to claim that the defense is to blame for ex parte pleadings that were accessible to the prosecution. 36. On March 7th, 2024, Attorney Rosie alerted Judge Gull about his grave concerns surrounding McLeland receiving the ex parte documents. It took Judge Gull 13 days to respond to this urgent matter. In her March 2024 emailed response, Judge Gull wrote to defense counsel, I would encourage you to educate your staff on how to properly file pleadings. Like it's their fault. Like she's talking down to them like little kids. God, I hate her. Okay, sorry. 37. Attached is a printout from the Docs Pop filing process of the February 26, 2024 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. So, footnote number 2 says in her May 31st, 2024 order, Judge Gull seems to believe that parties can only file ex parte documents through the Odyssey platform. If so, she is incorrect. Parties may also file ex parte documents through the DocsPop platform, which is the platform defense staff utilized when they correctly filed the February 26th ex parte document in this case. Over the course of this case, defense staff has used both Odyssey and DocsPop platforms when e-filing ex parte documents. It is telling that the tutorial Judge Gull sent to the defense details how court staffs should process ex parte documents they receive in the Odyssey platform, not the DocsPop platform. And we have that as Exhibit A. Wait, this is this is Exhibit A. Okay, so they're showing how they're logging it. It's just a print off of what they're doing. All right. So number 38. It should be noted that upon receiving this February 26, 2024 pleading, court staff would see in bold font and capital letters at the top of the pleadings the following ex parte pleading to be placed under seal. That's, I'm confused. That's not what Exhibit A says. I don't know. This is saying proposed ex parte order on funding for expert services. Maybe that's what was supposed to be under seal. I don't know. I mean, I'm assuming that's what they're talking about. Okay. I don't know why that would be under seal, but maybe they didn't want the prosecution to know who their experts or what kind of experts they were looking for at this time. I'm not really sure why they wanted that sealed in particular, but there might have been information about their whatever experts they wanted. So where was I? Court staff would see in bold font and capital letters at the top of the pleading, ex parte pleading to be placed under seal, which should have easily alerted court staff of the ex parte nature of the document, causing them to follow the proper proceedings or procedures in processing an ex parte pleading. Number 39, the staff for the defense filed the ex parte documents correctly. The Docs Pop printouts show that the only service contracts listed on the ex parte filings were Brad Rosie and Andrew Baldwin, not Nicholas McLeland, James Luttrell, or Stacy Diener. Furthermore, the printout shows that all documents were marked as confidential. Okay, yes, it does say these are all confidential. So that is what they're showing. This is how it was filed, showing confidential and going to Bradley, Rosie, and Andrew Baldwin. So those are the two people it went to. All right. Furthermore, the printout shows that all documents were marked as confidential. Okay, sorry, I read that already. Number 40. There is nothing else further that the defense can do to prevent these documents from being made public or misdirected to the prosecution. After the defense correctly files the ex parte document, the defense must then trust that the court staff has been properly trained on how to navigate an ex parte filing, whether it is filed using the Odyssey or DocsPop platforms. 41. In this case, after the defense correctly filed the ex parte motion, somehow court staff erred in how it processed the document into the system, causing Prosecutor McLeland to have access to the ex parte document. Number 42. In her May 31st, 2024 order, Judge Gull detailed how she sent the defense a tutorial paper authored by JTAC explaining the process. The court implied in said order that she sent the tutorial to the defense in order to assist the defense in learning the proper process of how to file an ex parte motion. Judge Gull's presumption that this tutorial assisted the defense is inaccurate for three reasons. Number one, the defense was not errantly filing ex parte documents. Number two, the tutorial Judge Gull sent to the defense had nothing to do with assisting practicing lawyers on how to file ex parte documents. And number three, the defense continued to file ex parte documents in the exact same manner it had been filing before Judge Gull ever sent the tutorial to the defense, and there were no issues. Number three, footnote in her May 31st order, Judge Gull, referring to the email in which she provided the JTAC tutorial, stated, since that communication, defense have had no issues with their staff properly filing ex parte pleadings. This court attempted to give credit to the JTAC tutorial for her claim that no ex parte issues occurred after she sent the tutorial to the defense. However, this is simply not true, as that tutorial provided no guidance for practicing lawyers, and as discussed above, the defense was already correctly filing ex parte documents. It seems likely that the actual reason for no further ex parte issues was that court staff actually learned the proper manner in which to process ex parte documents, or you were just getting better at hiding it, in my opinion. All right. So number 43, the tutorial they put in air quotes, tutorial, Judge Gull the tutorial that Judge Gull emailed to counsel is actually intended to assist court staff and clerks in how to properly handle ex parte documents after the private practitioner has filed the ex parte document. So after the attorneys, after they file it, then there's a process that needs to be done for the court staff to do. And they seem to potentially been the ones that might have not been filing it correctly. I don't know. That's kind of what they're saying here. So, I mean, it seems that way since now all of a sudden they're getting filed correctly and they've made no changes to the way that they've been filing things. So that's curious. In other words, this document that Judge Gull refers to in her order does not in any way assist the practicing lawyer in filing ex parte documents, as it is a tutorial for court staff. Please find attached printout of the tutorial that Judge Gull sent the defense marked as Exhibit B, which also includes the cheat sheet referenced in the letter from Office of Court Services. So here is Exhibit B. This is the letter from Court Services on how to, I'm not going to read through it all. It's just the letter on how to file ex parte filings, but it is for court staff and not for lawyers. So it's basically just a cheat sheet, a tutorial on how to file the ex parte filings, but it doesn't help them in the least. Number 44. Even though on its face this tutorial clearly appears directed to assist court staff in understanding how to process accept ex parte filings, the defense's staff still reviewed the tutorial sent by Judge Gull to determine whether any part of the tutorial was meant to assist a practicing attorney in how to file an ex parte document. It does not. When defense staff clicked on the link detailed in Step 1 and attempted to sign in, they were presented with a prompt that states you are not authorized to use this site. This is because, again, the tutorial that Judge Gull proclaimed in her order as helpful to the defense was actually meant for court staff. That's embarrassing. If she didn't know that and they just made her aware of that in a court filing like this, that's pretty embarrassing that you don't even know what you're passing around to help people and your own court staff can't get it right. Okay. Judge Gull has failed to admonish Prosecutor McLeland for improperly reading ex parte pleadings while continuing to denigrate defense counsel. Number 45. The pleadings errantly made accessible to Prosecutor McLeland were clearly marked ex parte. 46. The defense became aware that Prosecutor McLeland read the ex parte documents based upon a March 6th filing from the prosecution in which the prosecution directly quoted from the defense's ex parte filing from February. Oops. Oops, Nick McLeland, you weren't supposed to do that. This document was clearly marked in capital letters at the top of the document ex parte pleading to be placed under seal. Number 47. After reading Prosecutor McLeland's March 6th filing and realizing that McLeland had reviewed a defense ex parte document, Attorney Rosie sent an email to Judge Gull and one of Judge Gull's staff members, as well as to Nick McLeland. Find attached copy of said email marked as Exhibit C. The email is respectfully questioned. The email respectfully questioned how an ex parte motion was made accessible to the prosecution. So that is Exhibit C. So let's actually read through this. Here is Exhibit C. This one we will read. Judge Gull, you may be aware that I filed an ex parte motion for funds on 2/26/24, which contained confidential information regarding our client's defense. We have double-checked and confirmed that the only two individuals CC'd on the motion were myself and Andy. See attachments. This morning, I received an e-notice of a filing by Mr. McLeland requesting Dr. Westcott's records, and in his filing, There exists specific quotes from my ex parte filing on 226. Unless I am missing something here, this would suggest that Mr. McLeland has a copy of my motion. Naturally, this is concerning. In an effort to not jump the gun on this, my staff member did reach out to Karen in Carroll Circuit Court to confirm that she processed the motion in accordance with the ex parte confidential filing procedure, and she assured my staff that she did. I am not looking to point fingers here, but I think it's fair for me to inquire as to why our client's ex parte filing is not being treated as a confidential filing. I also think it's fair to inquire as to why the prosecutor would not only read the filing knowing it is noted as an ex parte pleading to be placed under seal, but moreover, why after reading the filing, the protected information would be reduced to a pleading and publicly filed by the state. So that was information that they wanted kept under seal, and the state just filed it publicly. So kind of defeats the purpose of the whole ex parte under seal. In a normal situation, I would simply pick up the phone and call Mr. McLeland to get to the bottom of this matter. But he has already made it clear to Andy and I that he will not communicate with us over the phone. I have no interest in engaging in dueling emails over such an important matter, so I am seeking your assistance. I would appreciate your thoughts on this and how to remedy the situation. Of course, I am open to Mr. McLeland's input as well. And finally, I am happy to discuss this by phone. This is more than enough to be courteous. Okay? I mean, I'd be fuming. This is a very super courteous email. Mine would not be so nicely written, I am sure. Also, there is the fact that the state's pleading is currently accessible to the public. Can't put the genie back in the bottle, but the rem- remedial measure of removing the filing would be appreciated. I look forward to hearing from you. B.R. Brad Rosie. So that was what he sent to Judge Gull. That was Exhibit C. So this email respectfully questioned how he's right. It was respectful. It was super nice compared to how I'd be feeling at the time. Number 48. Then on March 7th, Prosecutor McLeland filed a pleading in which he finally admitted that he also had access to 3 other ex parte filings. What? After reviewing the record, the defense believes that Prosecutor McLeland actually reviewed only 2 ex parte filings, as 2 of the filings that he referenced in his pleading he identified as ex parte are not actually ex parte filings. Okay, but still. Number 49. Despite the clear markings of ex parte on the documents, Prosecutor McLeland chose to read those ex parte documents rather than promptly deleting them and alerting the defense of the misdirected filing as required under Indiana Rule of Professional Conduct. A lawyer who receives a document relating to the representation of a lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. 50. Prosecutor McLeland never contacted defense counsel after receiving the ex parte documents as required under IRPC. The defense only learned of his violation upon reviewing McLeland's March 6, 2024 pleading, in which McLeland audaciously quoted directly from the ex parte document, thereby making said quote available for public view. Number 51, the act of McLeland reading from defense's ex parte documents provided the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. This is yet another example of a subversion of Richard Allen's due process rights. 52. This court has failed to reprimand the prosecution for reading ex parte documents or to even address that issue in any way whatsoever. Nor has Judge Gull filed a pleading in which she publicly proclaimed that she is referring Nick McClelland to the Office of Judicial and Attorney Regulation Executive Director Adrian Maring for the office to enforce the rules or determine counsel's ethical misconduct. And they're right. So she's put that in public filings about them, but yet Nick McClelland can just go around reading ex parte filings that he's not supposed to get his hands on. This quote is taken from Judge Gull's order or judgment. Yes, it was. We read that. So, blah, blah, blah. Concerning, it was in her order of judgment concerning the prosecution's request that defense counsel be found in contempt. That's when she basically publicly shamed them and said they were sloppy and unethical. She was going to report them to this Adrian Meering, the Office of Judicial and Attorney Regulation. So there's that. Nick McClelland has different rules, I guess, guys. 53. This court publicly declared in its April 30th, 2024 order that it was referring defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release, that defense counsel sent out to media sources when no gag order was in place and after that prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on the much more serious allegation of McClelland reviewing ex parte documents and violating IRPC, that's the Professional Code of Conduct, Judge Gull has said or done nothing. Judge Gull is clearly treating the prosecution differently than defense counsel, and this provides a rational inference of bias. Yes, it does. This court offered its hand-picked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for attorneys Baldwin and Rosie. Number 54, in her May 31st order denying the defense's request for disqualification, this court maintained that it has no bias against defense counsel. 55, on January 22nd of this year, this court denied Baldwin's and Rosie's request for a Franks hearing. At that point in time, this court has failed to rule on the Franks request for over 4 months. At that point, 4 months, she hadn't ruled. Yet within 4 days of their re-entering their appearance on the case, Judge Gull denied their request without hearing. And that's how it's been ever since they came back on the case. 56. However, after Baldwin and Rosie were taken off the case in October 2023, Judge Gull informed her newly hand-picked public defenders that they should review prior counsel's pleadings and either adopt those pleadings or make their own. In that November 14th, 2023 CCS entry, it was memorialized that Judge Gull informed the new public defenders, that was Scrumman and Libredo, that if defendants' new counsel inform the court they intend to pursue the Franks motion, the court will schedule a hearing. Number 57, such action demonstrates that this court is punishing Richard Allen due to her bias against attorneys Baldwin and Rosie, in that after they re-entered their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion while offering the replacement public defenders an opportunity to have a Franks hearing soon after their appearance on the case. 58. This disparate treatment of attorneys Baldwin and Rosie compared to this court's treatment of the prosecution and even of the replacement public defenders provides a rational inference of bias against defense counsel Baldwin and Rosie and therefore against Richard Allen. In this order, this court claimed that it is irrational and unreasonable for the defense to assert that as lawyers with 70 years of combined experience, they had never had the judge provide a hard end date for a trial. Calling defense counsel irrational and unreasonable shows bias, especially when this court is wrong in its understanding of Jury Rule 4. 59. This court unfortunately continues to malign defense counsel by calling them irrational and unreasonable for their av- averments that courts around. I want to know what that word is. Where's um, my phone? Averment is an affirmation or an allegation. In law, it's a formal statement by a party in a case of a fact of circumstance which the party offers to prove or substantiate. Okay. So this court, I like learning new things. All right, so this court unfortunately continues to malign defense counsel by calling them irrational and unreasonable for their averments that courts around the state of Indiana never set a rigid date for the trial to end. Implicitly, the court is also averring that defense counsel are lying about their experiences in other courts around the state of Indiana. Further, pretty much that's what she said. Like, that's just ridiculous that they have never had a end date. Like, come on, lady. God, I hate her so much. I do not like Judge Gull. I think she needs to be gone. I don't like to use the word hate, but I'm freaking done with these corrupt pieces of crap. Implicitly, the court is also averring that the defense counsel are lying. Furthermore, this court maligns defense counsel concerning its knowledge of the jury rules when it is the court that is incorrect in its assessment of the jury rules. 60. At the May 7th pretrial hearing, the court stated, well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summonses to the jury with the dates of the trial. Jury Rule 4 requires that I issue summons to jurors with the dates. That's a transcript from May 7th, 2024 hearing. And 61. The court cited Jury Rule 4 as a basis for limiting the time of the trial. However, Jury Rule 4 does not ever discuss the length of date or dates of the trial or require courts to place a hard end date for a trial. Jury Rule 4 states that, quote, not later than 7 days after the date of the drawing of the names from the jury pool, the jury administrator shall mail each person whose name is drawn a juror qualification form and notice of the period during which any service may be performed. The period which. So you could say it may take 4 to 6 weeks. You can give a time frame. You don't have to say a specific end date. Number 62. Jury Rule 4 is primarily referring to the time span or term during which citizens need to be on the alert that they could be summoned in for jury duty when they are on call for possible jury duty. So you could say you're on call for 8 weeks and you could assume that your trial is only going to go 6, but you could tell them a little extra time just in case, or whatever it is. I don't know. I don't know what the appropriate buffer time would be, but you know what I'm saying. So the prospective juror needs to be aware that over the course of a specified number of months, the court may summons them to appear in court as a potential juror at a later date. 63. Jury Rule 4. Oh, so they don't even have to know that they don't even need to know the dates, is what they're saying. Jury Rule 4 does not mean that they need to know the date. They just need to know that they're going to be coming up. They're going to be on call. 63. Jury Rule 4 further states that when summoning a prospective juror in for jury duty that, quote, the summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, including cell phones, PDAs, smartphones, etc., attire, meals, and how to obtain auxiliary aids and services required by the Americans with Disabilities Act. So nothing in there says trial dates. I didn't see it. Did you? All right. 64. Note that Jury Rule 4 does not require the court to provide the dates of the actual trial or the length of the actual trial, nor does Jury Rule 4 require the prospective juror to be advised of the beginning date or end date of a trial. So you know she was just making BS up when she said that. Well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summonses to the jury with the dates of the trial. Jury Rule 4 requires that I issue summons to jurors with the dates. No, it doesn't, Judge. And I think you know that, being a judge for how long you've been in Indiana. I think you would know that. All right, number 63, 64, I mean. Do that. Nor does Jury Rule 4 require the prospective juror to be advised of the beginning date or the end of the trial. 65. Jury Rule 9, term of jury service states, quote, a person who appears for service as a petit juror serves until the conclusion of the first trial in which the juror is sworn, regardless of the length of the trial or the manner in which the trial is disposed. I would think a judge would know that. 66. Once summoned in and selected as a juror, Jury Rule 9 is the jury rule that comes the closest to referring to the length of the actual trial. So she even quoted the wrong jury rule. 67. Note that Jury Rule 9 places no limit to the length of actual trial once a juror is selected, nor does Jury Rule 9 place a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the first trial, regardless of the length of the trial, the authors of the jury rules innately understand that courts will not have foresight to include an actual end date to a trial. As proof, in larger counties, jurors are summoned for a particular day and could be chosen to serve on any number of trials of varying lengths. Footnote number 6, in Marion County, for example, prospective jurors arrive and gather in a large room, not knowing which court or what trial they may be called upon to serve, as often multiple jury trials are conducted at the same time and on the same day. The prospective juror could be asked to serve any one of those trials. I mean, it's not that difficult. How have they been doing it for centuries now, and suddenly we have an issue? We don't know how to schedule a jury trial? It doesn't make sense. It's like all of a sudden they just forget how to do things in Carroll County when Judge Gull's uh, overseeing it. It's number 68. In spite of Judge Gull's proclamation at the May 7th hearing, Indiana jury rules do not provide or require a mechanism to limit the length of the trial whatsoever, including as it relates to the information contained in the jury summons that the court sends to citizens pursuant to Jury Rule 4. Number 69. Judge Gull's errant interpretation of Indiana jury rules created a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure for himself a trial where he could thoroughly present his defense without time restrictions. So Judge Gull forced the defense's hand in waiving their speedy trial option, their speedy trial option Yeah, it's an option, I guess. It's your right. Waiving that right to, in order to provide a more effective, um, to provide a more effective defense, they had to waive it because Judge Gull was not going to let them go the amount of time that the trial needed to go. She was giving them an end date, a stop date, and she wasn't limiting the state, so they weren't going to have evenly divided time even. So how's that fair? She forced their hand. She absolutely did. Number 70, Judge Gull's bungling of Mr. Allen's speedy trial right due to her misunderstanding of what the jury rules require in the summons only negatively affected the defendant and his constitutional rights, not the prosecution, and thus provides a rational inference of bias against the defense and Mr. Allen. Did she do it intentionally? Me think so, but I don't know about you guys. Do you think she intentionally forced them to give up their speedy trial right, and make them have to continue the trial again? 71. Additionally, at the May 7th, 2024 hearing, Judge Gull cited several cases over which she has presided that lasted less time than the defense is requesting on this case, essentially chastising the defense for the amount of time it was seeking for trial. Yeah, she was. The length of trial is determined by the number of witnesses, the amount of evidence, the length of the investigation, and the complexity of the issues involved. 72. This is the case of State of Indiana versus Richard Allen with its own set of facts, challenges, and potential pitfalls that could cause the trial to last beyond what the parties expect. For example, several witnesses reside 125 miles away. If those witnesses fail to appear in spite of being properly subpoenaed, the trial may be delayed while the parties try to determine how to deal with a witness whose car may have broken down or who may have simply ignored a valid subpoena. Maybe the judge told the officers to ignore a valid subpoena. That happens too in Carroll County. These situations arise in trial, especially in a factually complex trial with approximately 185 witnesses identified by the parties. 73. Additionally, of the approximately 185 witnesses identified by the parties, a dozen or more are expert witnesses whose testimony will generally take longer and will be more complex than fact witnesses. 74. For this court to call defense counsel irrational and unreasonable for stating the truth that they have never had a judge set a hard end date to a trial provides a rational inference of bias against the defense. So, Judge, you don't think you're biased, but here are some rational inferences of bias that you've just done in the past like 24 hours. 75. Additionally, it is shocking and disconcerting that the court refused to place a limit on the time allotted to the prosecution by absolutely limited the time for the trial, thereby limiting Mr. Allen's time to present his case. 76. Under the court's prior order, the trial was to last from May 13th through May 31st, thereby allowing approximately 13 days for opening statements, testimony, evidence, rebuttal evidence, arguing of final instructions, and closing arguments of both parties. If the prosecution took 8 days to present their case, this would only leave 5 days for Mr. Allen to present his witnesses, which include at least 5 expert witnesses without even factoring in rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments. How in the world did she ever think that this trial would be done in 13 days? She knew. She knew it wouldn't be. Number 77. The hard limit on the end of the trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process for witnesses, and his 14th Amendment due process right to present a defense. 78. In the context of its request for Judge Gull to disqualify herself, this court's maligning of defense counsel as irrational and unreliable, when in fact it was the court that was wrong in its understanding of jury rules and also wrong in its claim that courts statewide provide a hard end date to a trial, offers a rational inference of bias against the defense. Judge Gull's May 31st, 2024 explanation for her denial of defense motions without a hearing provides a rational inference of bias. 79. In its May 31st, 2024 order, when explaining why the court denied several defense motions without hearing, the court stated, if pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. 80. This court knows very little about this case, especially compared to the lawyers litigating the matter. Therefore, how could this court determine what evidence would be admissible or inadmissible until a hearing takes place and the defense moves to admit the evidence subject to possible object by the prosecution? I mean, objection by the prosecution? 81. Judge Gull's claim that defense evidence is inadmissible before conducting a hearing and before listening to the defense's contextualization of the evidence surrounding their legal arguments provides a rational inference of bias against the defense. 82. This court's denial of defense motions without a hearing based upon the reasons this court cites in its May 31st order establishes that this court is prejudging defense evidence as inadmissible. Also, this court claiming that the law does not support the defense pleadings before this court even hears any evidence is additional proof that this court is prejudging evidence. This court's denying the defense's requests contained in its pleadings without a hearing based upon her prejudging evidence provides a rational inference of bias. 83. In the future, if this court denies defense motions based upon the court's belief that the defense pleadings is not supported by the law or admissible evidence, the defense then requests this court to identify the evidence cited in the defense's pleading that this court believes is inadmissible and then to explain why the court believes the evidence is inadmissible. Also, instead of simply stating denied without hearing, the defense will request that the court explain why the pleading is not supported by the law. Stop giving us your BS denied without hearing orders that don't tell us anything. Even concerning something as basic as a request for a recess, Judge Gull shows favoritism to the prosecution. What? 84. In her May 31st order, Judge Gull expressed that she does not show favoritism to the prosecution. However, Judge Gull has shown her differential treatment based or between the prosecution and the defense in a variety of ways. Some are easily identifiable and some are less perceptible. 85. For example, because cameras have not been allowed in the courtroom, it is difficult to hear Judge Gull's angry tone when addressing the defense versus how she speaks so soft and nice to the prosecution. And also to visualize the court's disdain facial expressions that she makes towards the defense versus the prosecution. Those are things you can't see without cameras. In the future, the defense will likely request cameras in the courtroom for all hearings and trial for purposes of transparency and to better preserve the record. Yes, thank you. Absolutely. We would like that. We, the public, need to keep her accountable too. So the more that people see of her acting like a total biased, crazy psycho, then they're going to realize that Judge Gull has no business being a judge, let alone being on this case. So, I mean, she needs to go. I can't say it any louder. If I lived in Indiana, Carroll County, I would be picketing her and making her leave the bench, forcing so much public scrutiny against her that she would have to resign. I don't I don't know why this isn't happening in these corrupt towns as much. I mean, look at the effect that the protesters had in Karen Reid. They absolutely had a huge effect for all the corruption that was going on in there and to help shine a light on all the corruption. Sorry, my dog was eating a bone. That's what it was. I was hearing a noise and I was like, what is that? All right. So where was I? I love that they are going to be requesting cameras for every hearing. She's going to deny it. Love that they're doing it. All right, so 86. Although it may seem petty or trivial to the court, the defense offers an example of her disparate treatment concerning something as mundane as how the court handles a simple request for a recess during a hearing. 87. At the June 15th hearing, prosecutor this was back in 2023, the June 15th, 2023 hearing, Prosecutor McLeland requested a recess, and the following transpired. McLeland says, Judge, I have two witnesses. Could I ask the court for a short recess just so I can use the restroom? Would counsel approach? Judge Gull says, and then there's a sidebar conference conducted. Judge Gull says, I just want to know I just want to know what kind of where we're at. You've got two witnesses. McLeland says Tony Liggett and the Westville warden. Judge Gull says, okay, do you want a break for lunch? Rosie says, I don't, but Judge Gull says, okay, so I don't, McLeland says, I don't care. I can, and then he says something that's inaudible. Judge Gull says, yeah, we could take a quick break. How long? McLeland says, I don't mean to be a pain, but Judge Gull says, no, 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 that's all right. How long do you think you'll be? McLeland says, downstairs and right back up. Judge Gull says, no, no, no. I mean in your witnesses, with your evidence. McLeland says, oh. Judge Gull says, ding dong, I don't care how long it takes you to go there. No, I don't care about that. McLeland says, I don't really think too long. Tony about the transportation resources and then Gallipo just to address allegations they made in their safekeeping. Judge Cole says. So like another like half an hour or hour and a half, sorry. I guess I just couldn't. Judge Gull says, let's break for lunch. I know you don't want to, but too bad. Wow. Rosie says, I'm fine with whatever. Judge Gull says, okay, let's just break for lunch. Rosie says, I don't have anywhere else to be. I need to be. Judge Gull says, well, I know you don't because you were supposed to be here for 2 days. Wow. Wow. All right, so 88. However, at the May 7th, 2024 hearing, the court treated the defense much differently than the defense sought a short recess to confer with their client on urgent matters concerning the positives and negatives of continuing Mr. Allen's speedy trial due to Judge Gull's hard end date of May 31st. Following a back and forth exchange between Judge Gull and defense counsel concerning the defense needing more time for trial than Judge Gull was allowing, this occurred. Rosie says, can we have a 5-minute recess? Why? Rosie says, I would like to speak with my co-counsel here and I have a discussion about the business issues such as scheduling not here in the courtroom where everybody's listening to us. We've got, 50 staff members in the courtroom, people sitting behind. There's no privacy, and I'd like to talk to him in the hallway about some of the logistics of this so we can solve this problem so that Mr. Allen, can put on a defense. Judge Gull says, does the state of Indiana have any objection to a recess? Seriously? You're going to ask if he has an objection to a recess. He says, no, Your Honor. And she says, all right, Jody, you can go off the record. So because McLeland says it's okay, you can have a recess. But when Brad didn't even want to break for lunch, you gave McLeland lunch because he needed more time to get ready. Okay. I think she just gave the lunch because he said he didn't want lunch. 89. Judge Gull did not playfully call Brad Rosie ding dong, but instead questioned Rosie's reasons for seeking a recess. Then Judge Gull surprisingly asked the prosecutor if he, the prosecutor, had an objection to seeking a 5-minute recess so that defense counsel could talk to their client about the important matters concerning seeking a continuance of a speedy trial due to the trial court's unwillingness to provide more time to the defense counsel or to the defense at trial. 90. When a defense attorney requests a 5-minute recess to talk to their client on such weighty matters as their constitutional rights related to continuing a speedy trial, it should be met with a simple, of course, and should not require approval of the prosecutor. Hell yeah. Me fired up. Getting angry. All right, so 91. The fact that Judge Gold treats the defense differently on such a basic matter as requests for a recess provides a rational inference of bias. This court failed to address the appearance of bias which exists in this case. 92. Judge Gull claims in her order, as counsel should know, criminal cases are tried in a court of law, not in a court of public opinion. 93. However, the standard for recusal is not just whether actual bias exists, but also whether the appearance of bias exists. The mere appearance of bias and partiality may require recusal if an objective person knowledgeable of all the circumstances would have a rational basis for doubting the judge's partiality. And I think a lot of us are already there, judging her impartial or her partiality. 95. The emails which did I read the right one? No. Hold on. I read 8. All right. So the judge must consider both actual bias and the appearance of bias when determining whether to disqualify herself, which she did not do. She didn't even address the appearance of bias. She just said she's not biased, like in no other words basically than that. Like, of course I'm not biased. And we're just supposed to take your word. Number 94, Judge Gull appears to conflate the general concept that on occasion the public will vehemently criticize a judge with the defense's specific contention that many in the public are particularly criticizing her for what the public perceives is actual bias against the defense. Number 9, as part of the legal reasoning contained in her order, Judge Gull cites to being threatened with bodily harm and injury. She is not alone, as defense counsel have also received death threats and threats of bodily harm. Regardless, the defense sees no linkage between whether an appearance of bias exists and Judge Gull's mentioning that she or any other party has been threatened. And there doesn't need to be any connection. She's a public figure. People could be outraged by many things that Judge Gull does, not just in the Delphi case. Anyways. All right, number 95. The emails which the defense attached to the motion and the memes that the defense referenced in the motion detail how the public believes that Judge Gull is biased against the defense. Number 96. The defense agrees with this court and general complaints by the public concerning the court's rulings should not cause her to disqualify herself. However, that is not what the defense is discussing in this motion. What does it say? Okay, so number 10. It is true that many in the public have written both Judge Gull and the Indiana Supreme Court to complain that the judge is wrong in various rulings, particularly whether the judge should allow cameras in the courtroom. However, these complaints would not support an appearance of bias. They support that we all think she's biased. It is not what the defense is discussing in this motion. Number 97. Although the defense believes actual bias exists, it is the appearance of bias against the defense about which the public has complained. It is the appearance of bias against the defense about which the public has written the Indiana Supreme Court. It is the appearance of bias against the defense about which the public has written Judge Gull. And it is the appearance of bias against the defense, the existence of which Judge Gull should recognize and for which Judge Gull should voluntarily recuse herself. Failure to address other issues contained in the first motion to disqualify, 98. The court addressed a few other defense issues contained in their second motion to have Judge Gull disqualify herself. The defense stands by those reasons as well and does not waive those issues for purposes of appeal. All right, so 99. So they're saying there might be some other things that they didn't address in this motion, but we're not waiving our right to address those things. We're just talking about this disqualification stuff and getting her off the case. Number 99, however, in its May 31st order, the court failed to address all issues contained in the defense's first motion to have Judge Gull disqualified, which the defense incorporated into its second motion. 100. The defense requests Judge Gull to review the first and second motion to disqualify and consider whether she feels obligated to disqualify herself from this case based upon the itemized reasons contained in those motions, as well as in this response. So go back and read those. Reread those, Judge, if you even read them in the first place, and let us know why, for good reason, why you should not recuse yourself, because it appears to everyone else that she is biased. Conclusion 101. The defense wishes to move forward and have this court conduct hearings most immediately. The request to have Richard Allen moved from the DOC to either Cass or Tippecanoe County jails while awaiting trial. 102. This motion is intended to respond to Judge Gull's order for purposes of preserving the issues for the record, and so that Judge Gull may consider whether or not she feels obligated on her own to recuse herself from this case, which remains an ongoing obligation whether or not the defense is seeking her recusal. Wherefore, the defense files its response to Judge Gull's May 31st, 2024 order of judgment of the court concerning her denial of the defense request for disqualification, submitted respectfully Andrew Baldwin, Bradley Rosie, and Jennifer Auger. And that was, I believe it was the 18th. Yeah, June 18th it was filed. So, I mean, what do you think? I think this last part here is basically just saying, like, look, Judge Gull, there's a lot of things that we've got on you. It appears you don't want to let Richard Allen go. We really want you to. We really think you should. We're going to let you think about it one more time. We're going to let you even go back and look at those motions to disqualify one more time and think about it. Just think about it before we go any further, is what this means to me. Before we go on to take it to the Supreme Court or do whatever they have, like an appeal, like an interlocutory appeal, they can potentially do. I'm not sure if that would be the right remedy. I'm not a lawyer. I don't know. But they have a couple options potentially that they might be able to do to take it to, a higher court. I think, I hope, I pray that they can. I pray that she just recuses herself. Like, wouldn't it just be easier for everybody, Judge Cole? Just recuse yourself. Be done with them. Wash your hands of them. Say, I never want Brad, Rosie, or Andrew Baldwin in my courtroom again, and just be done with them if you don't like them. Just give them up. Give it up. Let go of this case if you cannot judge impartially. And she's not. She's obviously not making impartial choices. She has a bias. It's clear she doesn't like his attorneys. I don't know if it's because she doesn't like the attorneys or she doesn't like Richard Allen or it's both. If she equates the attorneys to Richard Allen, which she's a judge and should not do that, but she seems to be doing that. So I don't know. It's regardless, even on the slight off chance that she's not biased, all these things that they've listed in here and their other motions, they are saying there is an appearance of bias. So for that fact alone, Judge Gull needs to go. Let's get someone new, a special prosecutor or a special judge. Maybe get someone from a different county to come in and do this because Judge Gull needs to go. And that is my story, and I'm sticking to it. I've been saying that for a while on my channel here. She needs to go. She's not thinking impartially anymore. And that's all I have to say about that. What do you guys think? Do you think Judge Gull is going to just kindly go, "Oh yeah, I'll recuse myself," or do you think she is impartial? Do you think she can rule impartially on these people? I mean, I don't see it, but do you guys think that she can? I love that they are going to be asking for cameras for every hearing now. So what do you guys think about that too? I mean, if the defendant wants cameras in their own proceedings, how can you deny that? I don't know. I think their right to have a public trial outweighs anything Judge Gull wants. So that's all I have for you guys. Thank you so much for watching. Please don't forget to hit the like button on your way out. Make sure you are subscribed because I definitely go over um, Delphi documents whenever they do drop. I try to get them out within a couple days. I know I've been watching the Cured Reid trial, so I've been slow on getting things out this past couple weeks, but I try to get them out as soon as I can to you. So I hope you have enjoyed, and I hope to see you guys in the next one. Take care. Bye. Thanks for watching.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.